happens when the tiebreaker rules do not work and there is a dispute? So I'm going to start with this answer, and maybe I'll remember to also finish with this answer, and that is, I think in those situations, it's appropriate to also get a very good consultant in. And what I mean by that is an advisor to understand the countries that are at play here, who has dealt with this in the past, because you need really hands-on experience. Because as you'll see, if you start going into the detail, there's a few things that usually can happen. The first thing is that you enter the world of what they call mutual agreement procedures, a MAP. Now, if the tiebreakers rules within a double or DTA or tax treaty don't resolve the dispute, the affected taxpayer can request the competent authorities, as they say, of the involved countries to initiate the MAP. Now, in certain jurisdictions, there have been very few MAPs even successfully done internally or in country. So to do this cross-country and to end up with a MAP is a very difficult and it's a challenging experience. The other one is that the competent authorities of the two countries will negotiate to reach a mutually acceptable solution, and that's referred to loosely as bilateral negotiations, ensuring that the taxpayer does not face double taxation. So very important to appreciate that many times this is the first point of call after you, as I say again, have involved a consultant or a tax advisor with practical hands-on experience. The second option, if it is available in the jurisdiction, is arbitration. Now, there's a mandatory arbitration clause in certain of the modern tax treaties, which include this arbitration clause that comes into play if the competent authorities cannot reach an agreement within a specified period under the MAP. Now, arbitration involves an independent panel which has to make a binding decision. And the binding decision then made by the arbitration panel is typically binding on both countries, ensuring that the taxpayer does not suffer from double taxation, meaning that the one country goes with outcome of X, and the other country then still refers back to and resorts back to what the original issue was, which means that you're still back in your arbitration, in your so-called difference in terms of the tiebreaker rules. Then you have also an option which is called the unresolved dispute. And that's if the MAP arbitration doesn't resolve the dispute, then there are no binding, and there is no binding arbitration clause. The countries may unilaterally to proceed with their tax assessments. And this does actually, unfortunately, result in double taxation in most jurisdictions. And then you have to look at the legal remedies within the domestic litigation rules of the specific judicial systems in those countries. That's the best way to look at it. Now, unfortunately, the impact on a taxpayer from all of this is double taxation, and then, of course, your compliance and administrative burden, which could involve numerous and a very prolonged legal or administrative procedure that needs to be followed. One thing I would add, just to assist taxpayers and companies in general, is to consider looking at future treaty negotiations, and that's to lay this on the table of the relevant government, or where you see that you've got sufficient involvement or know the right people as a company or companies, and to consider involving the various dispensations or legal authorities or competent authorities to include this in future treaty negotiations. So as one can see, it's not a very easy situation to get yourself out of, and in many instances the MAP and arbitration rules are not very easy to follow in jurisdictions, and therefore one ends up with double taxation, which brings me to the point that be very careful when you start looking at involving other countries or deciding to do business there from a commercial point of view, because it may not be worth it because of these situations if you start doing investigations as part of your investment case before you invest in a specific jurisdiction. But if you are there, these are the remedies available, and always try and, if I can end off with that, try and involve a local consultant or advisor that has been successful in dealing with matters of this sort.